this Wednesday afternoon, February 5th. And we're looking at H118. I think we had some discussion yesterday, certainly can have some more discussion. This is the version that is slightly updated, but I'll turn it over to Ben with any to explain, to do a walkthrough of the amendment. This is version or draft number 1.1.
Thank you, Mr. Chair. Ben Novogroski from the Office of Legislative Counsel. Before the committee is an amendment, a strike-all amendment to H118. And do you want me to put it on the screen? It's very...
Sure.
Okay.
Pretty decisive.
So you may notice that this is not highlighted, the changes here, because this is edited and ready for a vote if the committee so chooses. But what you will see is that on page 1, line 11, the word particular has been removed from a group of particular persons. So now it would just read another person's or group of persons actual perceived membership in a protected category, ... And then again, the same change is reflected on page 2, line 4 in subsection B, that it would be a person's or a group of persons actual or perceived membership.
Okay, what exactly would perceived membership mean?
Based on a variety of
You
factors.
don't have to have a card.
No, but a lot of times, you know, to me, the example that comes readily to mind is like in a law enforcement encounter, oftentimes, you know, when we're talking about race data collection, it's perceived race, you know, based off of the outward appearance of the individual or other indicia of, you know, that might indicate their race. In this case, it would be something that might indicate their membership in a protected category. So for instance, if there was a mezuzah on someone's home, on their door frame, might indicate that they're Jewish, but maybe that they actually are not, and they're just doing it in solidarity with the Jewish people, something like that.
Okay. Or there's, you know, the Wisconsin case where
Exactly.
they perceived this person to be white. Maybe the person wasn't white, but that was a race basis that they attacked the person in that particular.
And so that's probably an issue that would be litigated within the case itself if it was based off of a perceived membership about what were those perceptions and what was the evidence that indicated X, Y, and Z. But it also might be indicated in the law enforcement officer's affidavit about what that perception was. So there are various points where it could come out, but inevitably, without having a crystal ball, that's probably something that would be litigated in court.
Any other questions for Ben? I've not seen any since I'm trying to vote this out, and we can certainly have some further discussion, but I would take a motion to approve the amendment draft number 1.1 to H118. All right.
Second.
For a second. Remind me, I can take a straw poll on the amendment part. It's on the bill as amended that we would take a roll call. So I will take everybody in favor. Well, first of all, I suppose we can have discussion of whether we should remove particular or not. I think I was pretty convinced by President Smola's testimony on Friday that we don't need that, and it kind of made it a little topical. So, any other discussion on that component? All right, so all those in favor of the amendment of taking out particular, please say aye.
Aye.
All those opposed, nay. All right, so
Opposed?
Yeah.
no.
Aye. You're saying.
Just
saying.
So it was almost unanimous, but we can move.
Now yours.
We can move to a motion. I'll take a motion to approve draft number 1.1 H118 as amended. In a second. Okay, Tom's the second. Any discussion? What draft did you say? It's draft 1.1.
I can fill it out later too. I just gave you the sheet.
Yes, yeah.
I'll have a brief discussion.
Please.
So I'm going to vote in favor of this, but I think we heard compelling testimony from both sides as to potential constitutionality issues. I think having reviewed the case law that was referenced, find myself also a little unsure about the constitutionality of it, but given also testimony that we heard about what we're trying to accomplish with this bill and the importance of that, and that there is a system in place to determine whether there is any issue of constitutionality, I think that it makes sense for myself personally to move forward and vote in favor of this, both here and on the floor. And I want to just appreciate the witnesses that we called. I thought that it was like really great testimony, which were very helpful in considering this.
You're welcome.
Yeah.
And I meant only that. That was the first time.
Yeah, so I mean, I read the cases that were referenced as well, and I found President Smolden's viewpoint of them more convincing. I really think this is not speech, it is conduct, and it's what is behind the conduct. You know, that we look at the mens rea, we look at the state of mind of conduct, from negligence to recklessness to knowingly to intentionally. In this instance, for an enhancement, we look at hate motivation as being part of the rationale behind the conduct. And I think it, even though the Wisconsin case specifically was talking about choosing a victim, I thought what was behind that, and several statements in the Supreme Court's case focused on conduct. I understand that that's just where I come out, and ultimately, this will probably be tried and go to our Vermont Supreme Court, you know, at some point, and they will have the ultimate determination of whether this is constitutional or not, or it could even go up to the U.S. Supreme Court, but seems less likely under this kind of law, but it's possible. So I think that, you know, I'm very comfortable that we have very good arguments that this is constitutional. So anybody else want to weigh in on? Yeah, Barbara?
I'm excited to vote for it. And I mean, I'm sorry that we need to have stronger laws to protect hate motivated crimes. But I'm excited to be able to close some loopholes that have existed, and appreciate the sponsor bringing it and the witnesses who have helped us to make this, I think, a strong bill.
Angela?
Well, I'll just say, I was just having a conversation with a couple of state attorneys. And you know, they were talking about what we have in the statute for if the maximum penalty is this, and if it's this, and you know, all those different. And they said, well, so if the underlying crime is, you know, more than 5 years, then we may not choose to, then like the enhancement doesn't really do much in a sense for sentencing or what have you. But, and I said, well, I think that's the point, that this is really in some ways for those crimes that do not already carry a really heavy, a relatively heavy penalty. And those where the underlying crime may not be so egregious on its face without the consideration of the hateful motivation. So that's why I think it's important. And I think it's always important from my point of view too, where we see gaps, as Barbara's describing, you know, whether you say loophole or gap, that we do our best to provide the language and the structure to fill those gaps, to offer more protection where it's needed. And that's what this does.
Anything else? Not seeing any of the clerk can call the roll.
Arsenal,
Yes.
Dolan,
Yes.
good now,
Yes.
so Slant, yes, Harvey,
Yes.
aye,
Yes.
did I pronounce that right?
Aye.
Did something right today?
Times in a row.
Oliver, yes, Rachelson,
Yes.
Christie,
Yes.
Burdick,
Yes.
Vaughn.
Yes. All right, thank you very much, everybody. I think it's a good bill and Angela has agreed, I think. Did you agree to report this bill? Unless somebody else is dying to report this bill? Anyone?
Candy.
So thank you, Angela, for that. And so I will confirm with Ann Donahue that right after the floor, like 5 minutes after the floors.
It'll be just email.
Okay, perfect. So right after the floor, Ann Donahue is going to introduce H26 to us. Hopefully it doesn't take long. And Ann is always very entertaining and informative.
Firearms bill?
No, it's a guardianship bill. Yeah, we'll get to that.